Good afternoon to everyone joining us. I'm Giulia Pavesi. I'm a space security researcher at KU Leuven, the Leuven Center for Global Governance Studies in Belgium, where I focus on the legal framework of reversible operations against space assets. Today is really a pleasure to moderate this panel. The first part will be about the legal regime of ASATs, and the second part will be about the relationship between the cybersecurity and the space security dimensions. To do so, we couldn't have a better panel. We will start with Anna Blechová, who is a PhD student at the Institute of Law and Technology at the Masaryk University and cybersecurity manager at the Prosecutor General Office in Czechia. And she will examine the issue of space debris as a space weapon. Then we will zoom out and we will go into a broader examination of the use of anti-satellite weapons under Ius ad Bellum with Dr. Chris O'Meara, senior lecturer in law at the University of Exeter and author of Necessity and Proportionality and the Right of Self-Defense in International Law, but also on the upcoming book on the right of self-defense in international law. We will then switch the focus on the relationship between space and cybersecurity, this time first with Mrs. Deborah Housen-Couriel, Chief Legal Officer and VP Regulation for Konfidas Digital Ltd, who also worked as a core expert on the Milamos project and as a member of the group of experts for the 2017 version of the Tallinn Manual. Finally, we will conclude with a EU perspective, this time with Dr. Stefano Mele, and with the main implications of the newly updated EU cybersecurity framework. Dr. Stefano Mele is head of the Cybersecurity and Space Law Department and co-head of the Privacy Department at Gianni Origoni, but also president of the Information and Communication Authority of the Republic of San Marino. The first two speakers will have 20 minutes, while the second speakers will have 10 minutes each, and then the Q&A will follow. And now, without further ado, Anna, the floor is yours.
Okay, so ladies and gentlemen, esteemed guests and fellow panelists, my name is Anna Blechová, as it was already said. I'm a PhD student from Masaryk University, and I am really honored to be there today and present the paper titled From Space Debris to Space Weaponry, a legal examination of space debris as a weapon. Before delving into the substantive content of the presentation, I would like to address a few disclaimers. First of all, our paper presents only the author's perspectives, not the perspectives of the Masaryk University in general. Secondly, we do not endorse any specific actions, or we don't recommend anything. And last but not least, our research relies only on the open source information. With that said, let's explore the critical issue of space debris weaponization. Cyber anti-satellite weapons could be possibly considered legal. Yeah, I can see that it could be like thought-provoking, and maybe like the guy in the last row is rolling an eye. But if you will give me like 15 minutes of your life, I will try to convince you that I am not totally insane. First of all, it is really necessary to introduce the environment itself. And in general, the space for a long time had been considered like a peaceful arena. This stems from the Outer Space Treaty itself, the Article 1, but also from the fact that for a long time it had been really challenging to technically bring the war into the space. Nevertheless, the situation is changing, and the terrestrial conflicts can extend into space, and the supposedly tranquil nature of the domain is slowly changing. The arms race is not definitely, it's like a vivid topic now, and space wars are not anymore just a topic for books or movies. So the change within the domain could be demonstrated by examples like NATO's recognition of outer space as an operational domain. However, in recent years, we have witnessed various successful tests of anti-satellite missiles. These tests were conducted by China, Russia, or India, and it's kind of understandable that these activities raised concerns among states and society in general, and thus it is not definitely weird that states are trying to halt these attempts on an international level. Unfortunately, we have states like Russian Federation who are not just stopping on the level of the anti-satellite weapons itself, but they are also like trying to more and more promote the attempts for the arms race in space. Besides that, and the Russia vetoing the UN attempts, it is also necessary to say that this state is ignoring the prohibition of placing the nuclear weapons in the orbit, and they are trying to go in this direction too. So, as you can see, the situation in outer space is kind of far from stable or from calm. And additionally to it, we also need to focus on the fact that the space itself and the industry is really changing. Because like back in 1960s, when all of the cosmic treaties were published, the state actors were the only one which were like focusing, which were like actively, which were like active in the outer space. But now we can see the growth of the private sector, which is gaining more and more attention. This could be seen or demonstrated by the predictions of the value of the market itself. In 2030, the prediction for 2030 was that the value of the industry will be around like $1 trillion US dollars, but the predictions for 2035 is saying that it will be like 1.8 trillion value of the market. And thus, we also need to deal with that fact like really carefully. So, anti-satellite weapons concern us not only due to their destructive capabilities, but also because of their secondary impact, the creation of space debris. This debris definitely poses a great challenge, and it could exemplified by the Castle syndrome theory. So what is the theory about? This theory illustrates a domino effect of the creation of space debris. In more simple words, as space debris accumulates, it poses an escalating risk, creating more and more space debris. And one of the most problematic aspects of this is that you need to keep in mind that in connection to the space debris in outer space, like the space debris itself, it is really reaching kind of really high speeds. For example, at it is estimated that at the minimum is like 17,000 kilometers per hour, and thus even a small flake of a paint could like create more space debris and like make a really destructive effect. So the Castle's syndrome, and in the direst scenario, the conclusion is that the density of the debris could be render critical orbits, such as the low Earth orbit, which is already overcrowded, unusable. And this is the main challenge we should avoid, or we should deal with it, because this would be definitely a kind of huge problem for all of us. So I hope that I described the environment and its biggest concern, which is the Castle syndrome. And now I will continue with the legal background and the applicable international law to this area. To provide a topic for our paper at the very beginning, it was necessary to focus on the question: is space debris if it is a space object or not? Because when we will go to the direction that space debris is not a space object, there wouldn't be a topic for the paper anymore, because the legal regulation will not cover it. So yeah, we came to the direction that space debris is a space object. And also, I want to point out that when I'm speaking about space debris, I'm following the NASA definition of the space debris. So I'm speaking about unfunctional, but also abundant but functional space assets and their parts, of course. So regarding the legal analysis, it's necessary to focus on the legal regimes that could be applicable in the field. And in general, definitely, it will be like the general international law. But the interesting question is if also IHL is applicable in outer space. The reason why it is an interesting question is because, as I said at the beginning of the presentation, the outer space is considered like for a peaceful arena. So maybe there is no space for conflict. Unfortunately, or yeah, this could be made to be the right word. We have Article 3 of the Outer Space Treaty, which is saying that all of the public international law could be incorporated, even for the outer space. And this is the reason why various academics believe that, and also practitioners believe that IHL is applicable in outer space. This debate is like still going on. Definitely, it's not like set in a stone, but I think that at least for now, the majority is going in this direction. And also, like the last point, like regarding that, is that even though we will say that IHL is applicable, it will not mean that the general international law will be like prohibited. It will be just complemented by the public IHL. Sorry. So yeah, I have introduced the general legal framework, and now I would like to pay the attention for one specific provision of the Outer Space Treaty. It's Article 9, which is setting the principle of non-contamination, responsible behavior, and also due regard principle. And from this provision, why I'm speaking about this provision is the fact that it's crucial for regarding the space assets and its secondary creation of space debris, because in connection to the threat of Kessel syndrome and the fact that we are still not able to effectively mitigate it, the space debris, not effectively mitigate the space debris. We could see that this article specifically could be violated, and it will be an international wrongful act. So, another really important topic regarding the paper is the area denial capacity of the space debris. I believe that, like by the previous slides, I successfully delivered the main idea of the weaponization of space debris and the connection to the Kessel syndrome. And regarding that and like the area denial capacity, I also wanted to point out that space debris is unavoidable. So even though we want to mitigate the challenge and the problem itself, we already have the problem to some extent in outer space. And so the space debris, especially in the low Earth orbit, is like creating another space debris, and thus, with in regard of the current legal framework, we can face some problems. As I described at the very beginning of the presentation, the described environment has changed, and from the situation when there was a dominance of state actors, we come to the situation when the private actors are more and more involved. Unfortunately, it's also necessary to say that the cosmic treaties haven't changed, and this is especially the problem of the responsibility and liability. I think that more in-depth analysis could be seen in the paper itself, which I'm presenting. So at least for now, I will try to skip it. And yeah, so. Cool. Sorry, I was a little bit lost at the beginning. So finally, I'm coming to the article main idea, which is the illegality of triggering the Kessel syndrome. Since I established the IHL applicability, I could really research the possibility of conducting the weapons review under the Article 36 of Additional Protocol 1. From the legal analysis I conducted, I concluded that the biggest deal breakers should be the area denial capacity of space debris from the assets and its environmental impact in general. It is especially the Article 35 and Article 55 of Additional Protocol 1. which states that it is prohibited to employ weapons that cause long-term and severe damage to the natural environment. And this is the exact situation we are facing in outer space. Moreover, we have to keep in mind that by creating space debris and weaponizing it, we could also find a violation of the Article 9 of the Outer Space Treaty. So, at this point, it's also necessary to make the distinction between the cyber assets and kinetic ones. With kinetic ones, there is no chance to avoid the creation of space debris itself and triggering the Castle syndrome. However, with the cyber assets, there is a chance to avoid it because, in really simple terms, with cyber assets, anti-satellite weapons, you can just turn off the satellite. There is a possibility that you will not change it into many small parts of it, flowing in outer space. So this is the reason why, under specific circumstances, the cyber assets could be deemed legal because they will be able to go through the weapons review test. On the other hand, the problem is that we have various types of assets, and I think that one of my colleagues will go more in deeper of that. But even the cyber assets could have the destructive effect because, for example, you can force the satellite to go into the direction of another satellite, and thus it will definitely explode and make the space debris. In this scenario, or the scenario which are similar like that, we will face the same problem as with the kinetic ones, and these specific cyber assets wouldn't be able to go through the weapons review test. So we are at the end of the presentation, and what are the key findings? Escalating cyber threats in outer space definitely raises concerns. I try to demonstrate it on the various situations, and it is especially regarding the cyber assets, definitely mostly by the asset itself, but the cyber attacks are also a topic. The threat of triggering the Castle syndrome and its subsequent environmental impact is an argument for the prohibition of the asset. This is reflecting to the very first idea I tried to deliver to you at the beginning of the presentation. And the reason why is it that so is because of the Article 36 of Additional Protocol 1. And yeah, this is building on the previous argument that kinetic assets could be deemed illegal in contrast to the cyber assets, which under specific circumstances, and as the lawyers like to say, it depends, situation, could be deemed illegal. And last but not least, in the paper, we found out that the dialogue on the existing legal framework for responsible behavior in connection to the assets and space debris should be definitely open more, because we can see this dialogue on the level on the political level, but we still don't have the dialogue on the legal level, at least for now. Thank you for your attention. I'm really looking forward to all of the great questions you will probably have.
There we go. Good afternoon, everyone. Welcome. Firstly, thank you to Giulia for chairing the panel. Thank you for the conference organisers, to Davide and others for inviting me to come and talk with you today and to discuss my paper entitled Anti-Satellite Weapons and Self-Defense, Law and Limitations. So I'm going to dive straight in. As the title of the paper suggests, the issue at hand is how states are limited in exercising their right of self-defense. Now, in terms of context, in terms of background, Anna set me up perfectly by explaining a little bit of the context and background, and in particular, how space is increasingly important for states. NATO and others treat space as an operational domain. And as we've heard, space is increasingly a militarized domain, a place potentially of conflict, a source of conflict, and increasingly there are concerns over potentially even wars in outer space. And this fact is evidenced by the testing and potential future use of anti-satellite weapons that can destroy or destabilize both military and civilian satellites. And just last week, you may have heard that the USA warned of a potential counter-space weapon being launched into space by the Russian Federation. So ASATs are increasingly a feature of the discourse among states, and increasingly, as we've heard, there are calls for the regulation of ASATs. And this is particularly urgent given, again, as Anna has perfectly explained, given the physics of space, and in particular the risks of these enduring clouds of space debris that might result from ASAT weapon use. So that's a little bit about the context and the background. Now, in terms of ASATs themselves, there are essentially four broad categories, I would say, emphasize the word broad. So we have, first off, physical kinetic ASAT weapons. So these are the typical anti-satellite missiles that may be launched either from the ground or from Earth-based platforms or from space, so co-orbital. We have non-kinetic physical ASAT weapons. So these are directed energy weapons included in this category, things like lasers, microwaves, electromagnetic weapons, again, either launched from space or from Earth. A third type are electronic weapons, such as jamming devices and spoofing devices that can falsify signals going to and from satellites. And of course, particularly of interest for this conference, we have cyber operations, cyber attacks that can target data and that can target satellite systems that use data. Now, we've heard a little bit already about the applicable law, so when we're thinking about ASATs and their use. I think it's fair to say that current international space law, as it concerns military activities, potential ASAT use, is pretty limited. We do have the OST, as you've heard, the Outer Space Treaty and the Moon Agreement. The takeaway for our purposes today is that neither of these two space law treaties prohibit lawful acts of self-defense, or using ASATs in lawful acts of self-defense. So where do we look to for the law? Well, as we've also heard, Article 3 of the OST effectively transports public international law from Earth into space. And that includes, crucially, the core provisions of the UN Charter. And I'll come back to those provisions in just a moment. So when we're thinking about this issue of legal regulation, when we're thinking about how ASAT use, even in self-defense, might be limited, how can it respond to this particular issue? So we've heard that weapons controls treaties have failed to date. There are ongoing efforts. We do have soft law codes of conduct, including from the EU and others, around this. And we have important academic efforts, such as the Milamos Manual, such as the Woomera Manual, which has just been published. But my argument really is that when we're thinking about military activities, much, not all, of the emphasis has been on international humanitarian law, the jus in bello, or the law of armed conflict, as it's sometimes called. And that's understandable when we're thinking about the IHL targeting rules, when we're thinking about targeting satellites. That kind of makes sense. But I also argue that the jus ad bellum, which I will explain in just a moment, is very much more under-theorized, and I think it is deserving of greater focus. I think there's an opportunity lost, really not in seeing the the ability of jus ad bellum compliance to constrain ASAT use and to respond directly to this concern that states and international organizations have about conflict in space and about ASAT use. So I think we should be focusing a lot more on the jus ad bellum and including the requirements of necessity and proportionality, which I will explain. So just to sort of drill down into this argument in more detail. First off, we must remember that when we're thinking about ASAT use, it's not just all about IHL, as I've just said. There are two key bodies of law that potentially apply to ASAT use. That doesn't mean they're the only ones. There are potentially other bodies of law. But for particularly military use, when we're thinking about targeting satellites, the two key bodies are the jus ad bellum and the jus in bello. So the jus ad bellum, as I'm sure you all know, regulates when states may lawfully use force in their international relations. It speaks to the question, why? Why are states using force up in space? What is their legal justification for doing so? The jus in bello, IHL, meanwhile, is the body of law that regulates the conduct of armed conflict, regardless of the why question, regardless of how states have got themselves into a situation of armed conflict, those rules apply. But as you can see from the slide, we need compliance with both bodies of law in order for ASAT use to be deemed lawful. So we need legal compliance independently in both bodies of law for ASAT use to be considered lawful. So from the jus ad bellum perspective, therefore, for those of you who are not experts and not familiar with the jus ad bellum, essentially it's grounded in the UN Charter as well as in customary international law, very much centered on Article 2.4 of the UN Charter, which I'm sure, as you know, prohibits states from threatening or using force in their international relations, subject to two key exceptions, or explicit exceptions anyway, located in the Charter. So force that is authorized by the UN Security Council under its Chapter 7 powers, and also, for our purposes today, the right of self-defense, that states have this inherent right, which is recognized by Article 51 of the UN Charter. So the key takeaway, again, for the paper, for the presentation, is accordingly, from a jus ad bellum perspective, if we do not have UN Security Council authorization to use force, and a state has not consented to that use of force, any military activities against satellites using ASAT weapons or otherwise that constitute a threat or use of force must require a justification under the jus ad bellum as lawful acts of self-defense. Otherwise, they risk being characterized as unlawful, as a contravention, as a breach of Article 2.4 of the UN Charter. So this is why I think we must focus more on the jus ad bellum when we're thinking about actions against satellites. Now, in terms of how this works, when we're thinking about the right of self-defense, you'll no doubt know that the right itself is triggered by an armed attack, which is the wording under Article 51. And this notion of the armed attack is very much debated. It's controversial. It's been debated for decades and decades and decades. Some of the issues are on the slides here that you might be familiar with. And particularly for satellites, that's a tricky question, particularly if we're thinking about multiple user satellites where different states might be involved. Are they the victims of an armed attack? My paper doesn't really get into that. My paper really focuses on if there has been an armed attack, either in space or on Earth, what about the right of self-defense in terms of how it might be exercised in space? So I look at the constraining influence of the jus ad bellum, and in particular, the customary international law requirements of necessity and proportionality, not mentioned in the Charter, but what they do is that they condition the exercise of the right of self-defense once that right has been triggered by an armed attack. So they apply to the entirety of a military operation triggered by the right of self-defense, and they ensure that that operation, those targeting decisions, are constrained and limited purely to the defensive. And these requirements of necessity and proportionality are essential. It just so happens I've written a book about that. Sorry to plug my own work, but you've got to take these options when they arise. But the key point of this paper and my ongoing research is to really see how these customary international law requirements operate in space when we're thinking about targeting satellites. So what does that mean for space then? So first off, necessity is well known, stipulates that defensive force must be a measure of last resort. Force used in self-defense must be the only reasonable choice of means available to a defending state or a victim state in the circumstances in which it finds itself. Only when non-forcible options on their own are insufficient or unavailable to a state does the necessity of using force in self-defense arise. So when we're thinking about alternative options to states using force against satellites, we're thinking about things like UN Security Council involvement, diplomacy, possibly countermeasures, and also those actions below the threshold of a use of force, right, which would not require justification by reference to self-defense, might require justification by reference to other bodies of law, but not self-defense. So we might be thinking here of limited cyber operations that temporarily disable a satellite, but which do not cause sort of physical damage, particularly if it causes the satellite to go out of orbit, maybe collide, and create this awful space debris that we are talking about. Now, if force is deemed the only reasonable response in the circumstances, then targeting satellites for military planners and policymakers might be considered a very attractive option indeed, because of course satellites, particularly military satellites, are integral to how military operations are conducted today, are integral to modern warfare. So neutralizing a satellite which supports aggressive behavior, supports the adversary, obviously is appealing. It makes sense. It might offer you a defensive advantage. But it does not follow that all satellites are fair game. So I argue that over and above this sort of reasonable choice of means hurdle, states also have to think about their targeting decisions under the jus ad bellum. And I argue that the jus ad bellum confines defensive responses to targets that serve a defensive purpose. So what that means is that defensive force must be directed against the source of the armed attack, so the aggressor, and the defensive force must be limited to military targets that are connected to the armed attack. And this JAB necessity targeting requirement applies in addition and in parallel to the IHL targeting requirements that many of you will be familiar with, particularly discussions around military objectives. So what does this mean for decision makers and military planners? Well, a number of factors, therefore, naturally arise from this jus ad bellum necessity requirement. Firstly, military planners must be very sure of legal attribution. You can only target an aggressor's satellite, therefore you must be able to identify the aggressor. Who did it? Who did the armed attack? And that's not always easy to establish. Attribution is a tricky thing, and it might be unclear, particularly in space, for example, if the armed attack is being carried out maybe by an anti-satellite weapon through cyber means. You might not be able to identify who did it. If you can identify it, well, then the other sort of hurdle to overcome is the nature and composition of certain satellites. So as I said, targets must be military in nature. You cannot target civilian or commercial satellites. But of course, as you know, satellites might be mixed. They might be mixed in terms of who or what is using them. They might have more than one owner or user. But they also might have mixed purposes. They might have multiple payloads. Some payloads might be military, some payloads might be commercial or civilian in nature. The payloads themselves might have dual use. So some payloads might serve military clients, some payloads might serve civilian clients. So communication, navigation services are obvious examples here. Think of SpaceX's Starlink, for example. So these factors pose significant challenges for military planners, and I argue logically limit a right of self-defense, defensive action against satellites. So I say that only targeting satellites that are solely owned, operated, or used by the aggressor, which are exclusively military, and which are factually connected to the armed attack, will likely satisfy JAB necessity, jus ad bellum necessity, and therefore be targetable under the jus ad bellum. Okay, so that's the necessity. If you can overcome that jus ad bellum necessity hurdle and also the IHL targeting hurdles, jus ad bellum proportionality is also likely to be a very significant limiting factor when we're thinking about targeting other satellites using ASATs. So unlike IHL proportionality, jus ad bellum proportionality operates at the strategic macro level to limit a defending state's total military response. So we're looking at the defending state's response as a whole. So in this instance, jus ad bellum proportionality is a prohibition against excessive overall military reactions by states which are undertaking necessary acts of self-defense. So jus ad bellum proportionality allows states to effectively defend themselves, but it requires that states don't do any more than that. They only achieve a defensive purpose. What I mean by that is halting, repelling, potentially preventing an armed attack, but no more. The self-defense must be linked to a defensive purpose, and in deciding whether that defensive purpose is met, we are also looking at the effects of that self-defense on other actors, so civilians and also third states. And JAB proportionality, jus ad bellum proportionality in this regard is particularly significant in outer space, particularly regarding the issue of space debris that we've heard, which can be long-lasting, it can last for years. And this threat of space debris, its effect on things like international peace and security, the space environment is a constant theme among international organizations and states when they're thinking about the threat. So NATO, for example, speaks of the potential conflict, of how conflict in space might affect all space users. And the UN General Assembly likewise speaks about the significant threat to the space environment of destructive ASAT use, both in terms of conflict and also the sustainability of the space environment. So the takeaway here is that ASAT use in space from a proportionality perspective may affect all satellites in orbit. It doesn't discriminate. And adherence to jus ad bellum proportionality directly addresses that concern. So when we're thinking about applying proportionality to ASAT use, we are balancing defensive force against that defensive purpose, and we're taking into account the effect on two key factors, being civilian harm and third-party rights and interests. So most significant for civilian harm is the potential harm to satellites owned and operated by civilians and corporations, but which also provide services to the civilian population. And that risk is hugely significant, particularly if we think about PNT services, so global positioning, navigation, and timing services provided by the GPS and its equivalents, which are absolutely central to how societies, how states function today. If we think about transport, financial markets, communications systems, critical infrastructure, military operations, etc., etc., etc. So even a temporary disruption to these PNT services could have disastrous effects for civilians, both in space but also on Earth. And we may envisage both physical harm, we may envisage economic harm, but we are also potentially thinking about death and injury to civilians. So accordingly, I argue that the jus ad bellum proportionality, taking into account this factor of civilian harm, arguably rules out directly targeting satellites that provide PNT and equally essential services, as well as targeting other satellites, for example, in proximal orbits, where the destruction of those satellites put those essential services at risk because of resulting debris. And I say that even the use of non-kinetic ASAT weapons, such as cyber attacks, are potentially problematic under the jus ad bellum if they are disrupting these essential services and potentially causing harm to civilians. Likewise, third-party interests. So states might have their own satellites, their own services which might be affected. There are other legally protected interests that we must think about, including neutrality, perhaps more importantly, protection of the environment, the outer space environment, in which all states have an interest. It's the province of mankind, after all. But also, all states have an interest in international peace and security, which is legally protected by Article 2.4 of the UN Charter, and which may be put at risk if there are in-orbit collisions. As we've just seen from the UN General Assembly, that's a real fear, and that might implicate matters of international peace and security. So jus ad bellum proportionality requires decision makers to consider all of the effects of its targeting decisions, both in space and on Earth, including civilians and third-party interests. So even non-kinetic alternatives might be problematic if the effect on these interests are equivalent and comparable to kinetic use. Now, that said, not all potential targets will be problematic, particularly if ASAT weapons are used in a targeted, limited way. There's no space debris. The target is not a PNT service provider. But there are inherent risks in targeting satellites using any type of ASAT weapons. So I caution states in how they approach this, and particularly to think, well, is there an Earth-based equivalent, an alternative that can be achieved in terms of achieving a similar or the same defensive objective? So, for example, if you can neutralize a satellite not by targeting it in space, but by targeting a control node on Earth, preferably away from civilians, I argue that is a natural consequence of applying proportionality, and decision makers should take that option. So to conclude, without weapons-controlled treaties, I argue that the jus ad bellum, alongside IHL, other bodies of international law, must be regarded as an essential part of the international law framework, the toolkit, limiting ASAT use and addressing these concerns that states have about the fears around weaponization of space, wars in space. Jus ad bellum compliance means that the ASAT weapon use in self-defense is heavily restricted. It might be denied in many, but all but the most extreme circumstances. Generally, targets of self-defense should be confined to Earth. If decision makers want to target satellites, they should take extreme caution. And alternatives to ASAT weapons that cause physical damage should be avoided to reduce or rule out space debris. But ultimately, thinking about your necessity and proportionality, understanding it better helps to avoid conflict in space, the escalation of conflict in space. It helps us to preserve space for all mankind and to protect international peace and security. So I shall leave it there. I shall thank you for your attention. I look forward to your questions. Thank you.
I'm Deborah Housen-Couriel. I want to thank Giulia for her moderation of this expert panel, and to David and his team for the organization behind this session and the rest of the sessions. They've been truly interesting. And I want to include in that the conversations in the corridors, which are always a real benefit here. So since time is short, I'm going to try to do under 10 minutes. I'm going to start with the main point that I hope to convey, following up to Anna and to Chris's really interesting presentations. As Giulia has already noted, it's a bit of a zoom out, and we're going to look at the relationship between cyber law and cybersecurity law and outer space law. And I'll start out by saying that the legal developments have up until now taken place really in two silos. And when I refer to two silos, I'm talking about separative normative processes for cyber and for outer space, separate epistemic communities, separate regulatory and legal policy documents, and the list goes on. So this is true both at the international law level, where we've really spent our time so far, and also at the national legal level. So we'll take a glimpse at both. Transformation does seem to be taking place in the direction of the convergence of these two silos. And there's increasing recognition by lawmakers and by decision makers that the nexus between the two, of cyber law and of outer space law, is really a critical one. In the next few minutes, we'll look at some of the points of connection, raise some questions and dilemmas about how these separate silos are developing, and see where they might converge. So I'm going to start with this quotation from 2016, so it's a bit of a blast from the past, from Gianni Robinson, who really, in my view, really makes the connection very succinctly. Neither space nor cyber can exist without one another if we really think about it. It's easy to think about this. There are no, so far, despite Arthur Clarke's ideas in the past, no cables that run up into outer space to manage communications and allow communications physically. Everything happens through cyberspace. So the domains are codependent. And the second point is that the cyber attacks, and some of them have been referred to by our two previous speakers, they're not new. And their targets are diverse. So take a look at this list. So Kuwait-based Al Jazeera has had broadcasts and transmissions attacked for years. Content has been changed, blocked. The Turla hacking group in 1997, especially, and before and after, has targeted satellite-supported internet communications and diverted them successfully. 2014 and 2015, the US Joint Polar Weather Satellite Systems also attacked with a risk at a level of high severity, according to the US GAO. 2019, just to take one example, large-scale Russian hacking of airplane and ship GPS. You also referred to that, Chris. So, and the Viasat ground segment attack, which we all know by heart by now. I want to quickly take a look at some future vulnerabilities and widen the scope. Most importantly, I think, in the context of space law, to looking beyond satellite systems. So, as Anna has explained to us, the Kessler syndrome via cyber ASATs for sure. Space-based cyber hacks, which Chris has explained to us, absolutely. But we need to take a look at supply chains for space systems, which may be terrestrial, which may be, as time moves on, and we have more and more facilities that are physically located in outer space, either on space objects or on Moon, Mars, and other places. What do those supply chains look like, and how do we protect them cyberly? And then finally, cyber hacks that impact beyond satellite systems, facilities that will be on other space objects, space stations, physical facilities, things that we can't even imagine yet. So as well, in addition to satellite systems, I think it's very important to widen the scope of what we're looking at in terms of cyber protections, under the assumption that, again, there are so far no physical wires into outer space. We're needing to rely on cyberspace for all space communications, terrestrial, Earth to space, space to space, and in all directions, so encompassing all of those. So, whoops, I'm sorry about that. In addition to widening our lens to look at the physical points of cyber protections that need to be implemented in outer space, we also need to look at the entire timeline of going back to satellite lifespan, but equally applicable to other space objects, from pre-launch and launch systems that are ground-based, and including the supply chains that lead up to them, sometimes for years, in the production of certain elements of space systems, to the TT&C, to physical destruction or disabling, to disruption of transmissions in the full taxonomy. And here I've listed perfidy under the lists of those vulnerabilities, and owe a debt to my friend and colleague Kubo Machak, who's in the room, who taught me so much about the piece of perfidy under IHL, which is our only really glimpse into the IHL applicability, but certainly something to look at, and a cyber vulnerability to space in space objects. So more on that, if you'd like, during the question and answer period. End-of-life events, which Anna discussed in terms of space debris, certainly a cyber vulnerability as well as a physical outer space vulnerability. So Chris, at the end of his presentation, touched a bit on the issue of data-centered cyber attacks, and I want to bring the focus to that as well. And here we're moving a little bit from the international law context to the national law context, cyber law and space law, national space laws, in terms of how private sector actors are becoming into the fore as relevant subjects of law in outer space and in cyberspace. We all know that, again, often even in my brain, there are still silos there. How do we think together about merging vulnerabilities? For example, when we have blockage or disruption of satellite to Earth video or data services, weather information, for example, can be disrupted by cyber attacks. The timekeeping piece, so Chris also referred to that, VNT service is critical. Communications and data storage, just had a colleague write to us in my other hat as with the company I work with. They're setting up a data storage system on the moon. It's happening. Can we do cybersecurity for that kind of a system? We haven't answered yes yet, but we'll have to see. Targeted hacks of direct broadcast emissions, which again bring into our consciousness the vulnerability to cyber hacks of content, which originates in space or is relayed through space. So all of these are data attacks, yes. And again, since I'm not restricting myself to the international law piece of whether there's actually physical impact, starting to think about how other systems of law, national systems of law, contractual law, contract law, comes into the picture when we think about these kinds of disruptions is a piece that really needs to be integrated in my thinking, to our thinking about international law impact. Haven't found a more aesthetic depiction of these interactions, but what helps me to think about these issues is to move from thinking about cyberspace as a fifth domain, as The Economist called it, I think in 2016. If I have the year wrong, you can correct me. And to really think about this cyberspace vulnerabilities as running through space vulnerabilities, air vulnerabilities, land and maritime vulnerabilities. And when we think about the nexus between space security and cybersecurity, in the space-to-Earth context, Earth-to-space context, and space-to-space context, I think we really need to open our minds even further to cyber vulnerabilities that express themselves in space, or that have an impact in space, but that may originate in particular legal environments, such as the maritime environment and the air environment, which will have additional legal impacts on how we think about the outcomes. So just an offering to sort of open thoughts about how these different legal systems, both internationally and nationally, really come into play at the nexus of cybersecurity and outer space security. These are some of the common or similar evolutionary tracks that I look at when I think about these two silos. So you can take it into yourselves, but there's the parallel thinking or the complementary thinking that we need to use when we talk about collective security issues, which Chris has gone into in quite a lot of detail, and peaceful use issues. And he's already done the hard work on that piece, so I'm not going to go into detail. Liability issues, both in space security and cybersecurity, look the same from some aspects, different from some aspects. Where do we find the common nexus, especially looking at private sector actors? Standards, really key issue that lawyers don't often like to look at. Standards are for the techies, but more and more as we have difficulty, challenges in elaborating normative systems under international law and under national law, I think a lot of times the engineers and the techies have some of the answers that the legal systems can't provide by putting in place standards for cybersecurity, standards for space security that are often de facto have more impact than emerging legal regimes. So that's certainly something to look at. It's not a solved problem. All of the standards both for cybersecurity and for space security are under development and need a lot more state practice and private sector practice in order to really prove themselves. But it's another sort of path to look at. I'm sorry, and one more thing I really want to underline, and Chris also mentioned this a lot, where the nexus really comes together, I think, is the need for cybersecurity for satellite and space objects that are critical infrastructure. And this is a really interesting piece to think about, because space infrastructure, space objects and space systems are critical infrastructure, and they're so characterized. And moving ahead, we have a slide on the European NIS2 directive, which categorizes them specifically as critical infrastructure. And that's sort of a pioneering effort. So space objects in and of themselves as critical infrastructure. And then on a secondary level as part of the support systems for critical infrastructure on planet Earth. So there's sort of a double edge to how we look at the nexus of space security and cybersecurity through critical infrastructures both on Earth and in space. Quick look at the normative hierarchies of space law and of cyber law. So again, very, very similar. Space laws, consortium treaties, the 5 outer space treaties. Normative hierarchy of cyber law, again, national cyber laws. About 70, I've tried to count in some research that I've done of multilateral and unilateral declarations. There's some examples, and regional and bilateral treaties. When we look at these triangles together, we see these really parallel processes. And we see that the critical operative and normative nexus is pretty much ignored by each of the two. If I've sort of found an interesting link, I think it's interesting, between the OST Article 9, which refers to harmful interference in a certain sense, and ITU Constitution Article 45, which refers to harmful interference to telecommunications, I think also cyber communications in a different sense. The research has been done on the background to a connection between the two in the minds of the drafters of each. There isn't one. So that's sort of an interesting point. We can come back to it in the question session if you'd like. Here's the final point, that we're really looking at two developing areas of law. Here's the instances of both the hard law and some of the soft law, and commentary, completely separately, with really no attention to the overlap in a formal sense. In the latest OEWG on reducing space threats 2022-23, you can see some of the points. There was no consensus on a final report, and it was a space-oriented piece of work. A little bit of movement in the direction of looking at cyber vulnerabilities in a very general way. So a movement to looking at overall sort of results-based analysis of where internationally wrongful acts may occur in outer space. And I would argue, a little bit hopefully, that that would include cyber vulnerabilities and breaches of international law in a cyber context. But it doesn't matter, I think, whether the honing and the clarification of the international legal obligations comes from the cyber direction or comes from the outer space direction. What's key is the nexus. What's key is that they meet in the middle, and I think that's, and again, I think that's beginning to happen. 2 recent examples, and then we'll wrap up. So take a look, if you have a moment, at the NIS2 directive, which is coming into force, I think, September of this year, finally. After lots and lots and lots of drafts. So we finally have the EU determining in Annex 1 to the sectors of high criticality, again, the definitions of sectors that are considered critical infrastructure, and here we have it. Space operators of ground-based infrastructure owned, managed, and operated by member states or by private parties that support the provision of space-based services, bingo. So we're starting to see that. We don't know how it's going to be applied exactly, but here we have space segment, the space segment being defined as a critical infrastructure, and cybersecurity for 10 other critical infrastructures that are all supported by, so far, satellite systems only: finance, health, energy, et cetera. That's one example. The second example has a good side and a bad side. The good side is here we have NIST's interagency report recently published to look at the introduction of cybersecurity for commercial space satellite operators, again, restricted to satellite, not all space objects, which is a pity. But I don't have the inside story, but originally an actual NIST standard was published in a draft form, and then was pulled back. If any of you have the inside story, I'd love to hear it during the interim, and during the question period, maybe. And what ended up happening was not a formal standard by NIST, which isn't a binding document, but has high level of recommendatory value. It was turned into a report. So a little bit of shying away from that, but I think it's a good example of what the direction is. Just to sum up, outer space and cyberspace are linked. We all have that assumption, I think, in our heads already. Need for ongoing coordination of legal norms, no question about it in my mind. We need to look, since we are talking about outer space, at different national legal and policy approaches. We know that they're different. We need to understand how, if we're already combining into a nexus two fields of law, how do we do that in the best way possible, taking into account different national approaches? Query roles and liability of private actors. We heard a little bit about new space. There's no question that ignoring private sector actors in outer space and in cybersecurity on land is not going to serve the purpose of moving ahead with the development of the law. A critical infrastructure, critical infrastructure, critical infrastructure. That's the way to move ahead with this nexus in the best, in the most effective and quickest way possible, I think. Use standards ASAP. And a key issue for the coming years, we'll wrap with this, is the liability issue, which we can only, which you've hinted at a little bit. But here we may, I think, interestingly, look to the private sector for some pioneering efforts, because the private sector is very much more used to including liability provisions in their business arrangements and their commercial arrangements with real consequences. So given the fact that new space is so reliant on private sectors, they may actually be the leading force to bring into the nexus of cybersecurity and space security issues of liability. Thanks for your attention.
Congrats. Very interesting. So, good afternoon, everyone. It's a good pleasure to be here. Thank you so much for inviting me also this year speaking at CyCon. I am really appreciate the invitation. It's beautiful for me to speak about a topic that I found very interesting. Thanks also to Giulia and all the colleagues for introduction, for this amazing, not introduction, amazing speech about space. And in particular, I would like to pinpoint with you in 10 minutes the conjunction between EU cybersecurity laws, EU, and space. So please fasten your seatbelt and be ready for this 10 minutes travel from ground to low orbit, to low Earth orbits and back about EU cybersecurity and space. Why? The first question: why is space a great target for attackers? There are a lot of reasons why space should be is a great target for all the nation states and criminal organizations in particular. But I would like to pinpoint with you 4 elements. The first one, Deborah said it, it's a critical infrastructure. Space is a critical infrastructure itself, but more and more services rely on the use of space technology and system. For example, navigation, communication, and defense. Space is also a central point of failure. The attack on a single element can result in the disruption of multiple services. And I will give you an example of this in 30 seconds. More, the obsolescence of systems. Many of the systems, for example, satellites, have a particularly long life cycle, long life span. And it's a problem for national security because in particular, the obsolescence of satellites should be resolved because it's vulnerable to cyber attacks more and more, in particular after we have opened the market to the private sector, and so we need to interconnect the private sector with, let me say, state space. And we need also to upgrade the software, the firmware that are in orbit, and we are creating a bridge from OT security and IT security. And last but not least, space is a great target also because if you have access to space system, potentially you can be allowed to seeing, to spying, for example, strategic, industrial, and military secrets. Those 4 elements are the most important, are not all the elements that we can looking at, but are the 4 more relevant elements that I would like to share with you this afternoon as an opening remarks of my speech. An example, we have Viasat cyber attacks in 2022. You can remember, no? On February 2022, Russian government disabled modems connected to the Viasat satellite network, which was used and is used worldwide and also by the Ukraine military. So the Russian government had gained 2 objectives. The first one was to blind the defense of military for a short time period, but blind in particular in the moment of the invasion of the territory of Ukraine, and for the spillover effect, and also the possibility, the objective to disrupt also the services, the satellite services of Viasat, that is United States private companies, perhaps, not perhaps, what's more, to disrupt the service, the satellite service in the European Union. So, which is the answer of the European legislator to these threats? The answer of the European legislator is following on a binary. On the left of this binary, we have a strategic legal approach of the European Union that is pushing more laws about cybersecurity, in particular following 5 pillars. The first one, risk assessment, risk-driven approach. The second one is sharing information about cyber incident. The third one is to impose cybersecurity measures adequate to the risk. The fourth is protecting protecting the supply chain. And the last one is to be audited by the authority. Those are the 5 strategic legal pillars that are on the roots of every European Union law, actually. At the NIS Directive 2, at the DORA regulation, NIS Directive 1, obviously, also the GDPR. We have a risk-based approach, sharing of information about cyber incident, data breaches, imposing adequate cybersecurity measure, verifying the supply chain, so for example, the processor of personal data, and to be audited by the authorities. So the approach, the strategic legal approach of the European Union legislator is based on these 5 pillars if we look at the first side of the binary. If we look at the other side of the binary, we have an approach that is most connected to verify the maturity of cybersecurity measure inside of our object processes, ICT hardwares, softwares, networks, and systems. It's in particular the Cybersecurity Act, and it will be the Cyber Resilience Act, with in particular using the first European Union cybersecurity certification scheme. In fact, if you want to pinpoint and highlight the more relevant aspects of the NIS2 directive, for example, we all know that was published in the official journal of the European Union, the 27th of December of 2022, and provides measure for a high common level of cybersecurity in the Union. And the scope is that by April 17th of April of 2025, the member states must establish a list of entities with the scope of NIS Directive 2. The approach of the European Union is to divide in 2 lists these entities. The first one is essential entities, and the other one is important entities. And in the essential entities, we find the space. So, is this enough? I don't think so, because the European Union legislator pinpoint that only the ground infrastructure of the space are under the NIS2 directive. But we need to protect also what is in orbit. We told before that we are interconnecting everything. We are opening the market to the private sector. we are connecting IT security with OT security. And this is real now. So probably we are missing an opportunity. We have missed an opportunity in the text, in the drafting the NIS2 directive to extend the application of NIS2 directive itself also to in-orbit infrastructure, services, network, system, and so on. If we look on the second binary of our approach, strategic approach, looking at the strategic approach of the European Union legislator, we find the Cybersecurity Act. As we all know, in 7 June 2019, the Cybersecurity Act gave a mandate to ENISA, that is the European Union Cybersecurity Agency, we all know, for the drafting of the first EU cybersecurity certification scheme. And ENISA published the first certification scheme 31 January 2024, the EU cybersecurity certification. And there is, as you probably know, a lot of debate actually on the cloud cybersecurity first certification scheme. So the approach is to create a framework for the establishment of a European Union certification scheme for the purpose of ensuring, again, an adequate level of cybersecurity of ICT products, ICT services, ICT processes. And what about, in the future, the Cyber Resilience Act? The Cyber Resilience Act is actually a proposal for a regulation, but it's important to know that rules for it is trying to rules for the placing on the market of the European Union of products with digital elements to ensure, obviously, the cybersecurity. But it will rule also for essential requirements for the design, for development, and production of products with digital elements. So we are trying at the European Union level, by law, to take the principle of security by design and put this principle on top of the process of design, develop, and production of products with digital elements. And it's fundamental to try to push this type of approach, to try to push security by design approach since the very high level step of the chain of design, development, and production of products with digital elements. So, Cybersecurity Act, the Cyber Resilience Act are the solutions for verifying with the certification or with the principle of security by design to our problem also in space. I'm sorry, but I don't think so. Again, it's not enough. In particular, Cybersecurity Act, and in particular, Cyber Resilience Act will look to consumers' technology more than highly critical products that we have in critical infrastructure, also in the space sector. 90% of the EU Cyber Resilience Act is focused on the design, development, and production, but of goods or products with digital elements, as the proposal regulation call it, for citizens, for European Union citizens, not for critical infrastructure. So we are missing another opportunity in my point of view. So if we look, going to the conclusion, if we look over the horizon, that is the topic of CyCon 2024. If we look over the horizon, I suggest to read the ENISA report. Is an impressive report of our European Union Cybersecurity Agency. The name of the report, as you can see, is Identifying Emerging Cybersecurity Threats and Challenges for 2023. And what I see after reading this amazing paper is, as you can read, with the new space economy, private companies have joined government agency in the space activity. So by 2030, the industry is likely to be further transformed, increasing geopolitical competition in space. And despite the importance of the sector, the issue of space security has only recently begun to be discussed. I quote also the paper of the ENISA in blue, and the ENISA said private companies may try to use this to sabotage their rivals, the weakness of our satellite, of our technology, of our infrastructure in the orbit. Private companies may try, say ENISA, to use this to sabotage their rivals. Government may try to exploit vulnerabilities to create a competitive geopolitical advantage in space, and criminal groups will use these vulnerabilities to extort companies for financial gain and to create havoc. I conclude, with this provocative question. So is really enough from the legal point of view? I'm sorry, I don't think so. I don't think so with NIS Directive 2, I don't think so with Cybersecurity Act, I don't think it will be with the Cyber Resilience Act, but what we must remember the transformation of the space sector globally, as well as an unprecedented role of space in determining European prosperity, competitiveness, safety, security, and autonomous decision-making. We must remember also that the competitive European space sector needs to continue to secure public and private space investment and capabilities of the private sector to take risk. We must remember the role of small and medium enterprises in this world. Not because I'm a lawyer, but it's a very relevant aspect, But the SMEs, the small and medium enterprise in space, we have remembered the pivotal role that they have and their contribution to the innovation and competitiveness again of the European space sector. We must remember the urgency of enhancing European autonomy as it regards security, safety, and resilience in and through cyberspace. And last but not least, we have to remember the need for European Space Agency, for the European Union, and for the Space Agency of the European member states to strive, when appropriate also with the SMEs, for progressing global rules and best practice in space, to allow for our European impact and a strong position on global space governance matters, including, and I conclude, in creating a sustainable space environment. Thank you so much, and I look forward for your question.
Thank you very much. I would suggest to open the floor to questions if we already have, otherwise I have a lot, so yes, please.
Thank you. My name is Kuba Mačák. I'm a professor of international law at the University of Exeter. Super fascinating panel. I loved all the 4 presentations. I need to still process some of the arguments made, but I'll start with the first half of the panel, just the 2 questions to Anna and to Chris, one each, if I may. That's why, the reason why I'm asking is because I'm very sympathetic to these arguments that establish strong legal constraints on what is permissible to do, particularly with the exceptional and unique characteristics of outer space, which deserves to be protected. So I just want to understand better the arguments that you are making. So Anna, for you, about the Kessler syndrome argument. So maybe 2 parts of the question. One is, could you clarify whether you believe that the argument you're making applies also to peacetime scenarios? Because so far the practice of anti-satellite testing has been in peacetime circumstances when a state struck its own satellite. So would the applicability of Article 36 extend to such scenarios and would make them unlawful in your opinion? And the second part of the question for you still is, I'm worried to some extent that if you tie your argument with the inducing of the Kessler syndrome, then because of the way that Article 36 is constructed, it basically looks at what is the expected or ordinary use of the weapon, right? So there could be a counter-argument, we are thinking about a higher orbital altitude, we're thinking of a more precise means that we have. I'm not an expert on this, but we have a reasonable certainty that this syndrome would not be induced. So would your argument still prohibit the exercises of force in those circumstances, even in armed conflict, yes, when there would be this counter-argument. Don't worry, it will not cause this outcome. And for you, Chris, I wanted to ask about the interaction between jus ad bellum and IHL that you touched upon a little bit. So you made the argument, if I understood you correctly, that satellites in question must be exclusively military in nature under the jus ad bellum for them to be possibly targetable under the criterion of necessity. And so this, as you know, doesn't tie in very well with our, with IHL, with international humanitarian law, where, of course, if something is a military objective, also when it is used for military purposes, but also for civilian purposes. So, you're thinking of a commercial satellite that might be used even predominantly for military purposes, for communications, etc., but it still has a residual civilian use. So is that, under your argument, is that impermissible? And how does it tie in, with the very predominant state practice, which is terrestrial, of course, in nature, but in which states are very clear that such targets are targetable in times of armed conflict, and there haven't been really, protests from other states saying, okay, maybe under IHL it's targetable, but jus ad bellum does not permit the targeting of such assets. Is it thus, are you just making a space-specific argument, or can that be extended to the terrestrial environment? And it's a new angle that we need to be looking at. Thank you.
We collect maybe other questions, and we can also extend a bit the panel of a few minutes, if, yes.
Thank you very much. My name is Ben Sekartis. I have written my BA thesis in dual-use space technologies and in their effects in the security policy. And my question would be that regarding how do you see the situation that an emerging number of private entities are gaining even more cyber and space capabilities than state actors, which enables them to unilaterally influence warfare, as we have seen with the startling participation in Ukraine. And do you think that an international regulation is needed? And if yes, how can it be done? Thank you very much.
I would say this is for Deborah, maybe. And one last question, maybe. So, or I jump in, actually. Yes.
Hi, Clémence Poirier from ETH Zurich. As you know, the EU space law project was postponed, which aimed presumably to include cyber measures. So right now, everything is a bit frozen because a lot of states at the national level at the EU started the process to update their national space law to include cyber measures. But they were waiting for the EU to proceed with the introduction of the draft and also to update and implement into their national law the NIS2 directive. So now everything is a bit frozen. So what is your opinion on this postponement? Do you think it's going to happen, this EU space law? Do you think that it's going to delay also the implementation of the NIS2 directive? Or is it going to be implementation of NIS2 directive in EU space law, but it's just not going to be adapted to space and consistent with that future EU space law? Thanks.
And that would have been actually also my question for you, Stefano, so it's perfectly aligned. Yeah,
Great.
You can start.
Thank you very much for the questions. I really like both of them. I think that I maybe even more like the first one because it's a great question. I understand that at least for now, the anti-satellite weapons are tested on the satellites that are owned by the countries they are testing it, of course. But it's also necessary to point it out that even though it's like that, so even though it could be some kind of the power move, still in the future, why they are testing it? They are testing it because they will probably want to use it someday, or at least it looks like that. And at least for now, even though if we will go to the peacetime situation, the Castle syndrome is that big threat that I believe that the applicability of the Article 36 should be also concerned regarding the peacetime situation. Because of the possible effect we have. The problem is that with the Castle syndrome, there are some authors which are already saying that it already happened. We are already in a situation when Kessel syndrome starts. It is not in that high speed as it could be in the future. So we are still at the beginning of the problem, to put it in like the more simple words. But if we will like put more and more effort to like spin it more, even in the peacetime situation, we will definitely have a problem. So this is the reason why I believe that it should be considered. On the other way, I understand that it could be complicated and definitely it could be controversial. And regarding the second part of the question, yeah, I am aware of the fact that the most problematic definitely is the low Earth orbit because it's overcrowded already. But this situation could just like move to higher orbits. So to say that there could be like an exception if the states will be in the direction that they will target the higher orbits. It will be kind of tricky because also on the higher orbits we have the most, not vulnerable, but like the satellites that we need more, like the GPS, GNS satellites are on not in a low Earth orbit in general, and thus I believe that, yeah, to put the argument in the way that if you will go like more up, it will be okay. It's definitely not like a good direction to go through.
Chris, on yours.
Thank you. My microphone's working. Yes, it is. Thank you for your question, Kibe. So there's no, I guess, clear answer to this, I guess. So if you're looking for bright lines, clear definitions in the jus ad bellum, we're going to be disappointed because we don't have those detailed rules, particularly written rules that you have in IHL. So the jus ad bellum is notoriously indeterminate. It's a creature of custom. We have to rely on the ICJ, which, let me say, has not necessarily done the best job ever with the jus ad bellum. So I'd say the following. So the co-application of jus ad bellum and IHL is, the key point there is to keep any targeting defensive. So if you're not targeting something that's military in nature, why are you targeting it? It cannot achieve a defensive purpose. In terms of what it means to say military in nature, all we have really is sort of ICJ dictum from the oil platforms, which is questioning whether the oil platforms were military in nature. So it cannot be necessary to target something non-military. In terms of what that means, again, I have a whole section in my book, sorry to plug that again, but basically what I say is that it might be the case for states that where they find a military objective for the purposes of IHL that also satisfies military in nature for the jus ad bellum. But that's not enough. That's not sufficient for the jus ad bellum. In addition, there must be a link to the armed attack in order to establish this defensive purpose. And again, if you're not targeting something which is connected to an armed attack, why are you doing it? Because self-defense is meant to be an emergency temporary response. So if it is military and it is connected to the armed attack, then it's much easier for states to satisfy the necessity under the jus ad bellum. And as to whether that applies in space and on Earth, yes, I think. I'm basically taking my analysis from Earth and seeing how it applies in space. So I think the same must be true for both. But of course, we don't have the clarity, we don't have the specificity with the state practice in a pinho juris. But that is the argument that I make.
So that's a very compelling answer, and I just wanted to come back very
quickly
about. just wanted to come back very quickly on the exclusive nature, because you know, in your presentation, maybe I misunderstood, but you said that the satellite would have to be exclusively military in nature, and so what I'm thinking of is, especially because you say that the same should apply, in outer space as on Earth. So if you have a communication satellite that's used, let's say, predominantly for military purposes, but not exclusively. Yes, so under IHL, that would be a military objective, and we would look at proportionality and precautions to determine if it's targetable or not. But if I understood you correctly, under your application of the jus ad bellum, it would not be targetable, so we would not even go to proportionality, because it would not be exclusively military in nature, given the residual civilian function. And this, I think, takes us to the area of progressive development of the law, but I think that's not where the law is at the moment. So
Yeah, I think the way I word it in my paper is I say if it is exclusively military in nature, states on sort of a safer ground. If it's not, be super cautious. You probably want to avoid that as a general approach, particularly if we're thinking about the resulting harm, because what is going to be the harm if it's also used by civilians of targeting it, right? And that might be unquantifiable, particularly if we're talking about PNT services, for example. But no, I absolutely take your point, but I don't think we have that precise level of clarity yet with the jus ad bellum because of its nature.
If I may jump in, actually there is also a very good piece of work from UNIDIR on this and on the dual-use nature actually of satellites, which actually clarifies quite well this discussion. So reading suggestions for the speakers, please. Yes.
So I wanted to offer a piece of a little bit possibly futuristic addition to this discussion, if I may. We're probably not far away from technical capabilities being able to, versus a situation where the entire satellite is taken out, to pinpoint specific transponders, which have been identified as military use versus of civilian use, so that very fine tuning is probably not far away and could ease the debate, perhaps. So something to look at. From that to a segue to your really good question, thank you, on private sector actors. I'll limit myself to 3 points, but I think you're really asking the key question and coming at the response as someone who's been trained in international law and reluctantly moving into the private law answer. No question that the private sector actors, both in outer space and in the cybersecurity space, have not only made huge strides, but in many cases, as many of us know, are ahead of nation states in terms of taking care of their pain points for both silos, both for cyber issues and for outer space issues. And the reason is that they have skin in the game, that they're taking risks and need to protect those risks. So this is point 2, especially with respect to supply chains. So we all know this as a result of our personal use of supply chains during COVID and the global logistics, which was so impacted by cyber attacks. The awareness on the part of private sector actors that this is really something that we need to take care of. They're not waiting for legislation. National legislation, yes, is moving forward, but contractually protecting themselves from both cyber exposures and for the outer space actors, outer space exposures. Third point, where does that land us? In a place which isn't often discussed in CyCon halls, or perhaps it should be more, the insurers. Insurance companies as drivers of the risk management, both in cyberspace and in outer space for these private sector actors. And we know, for example, from looking at commercial satellite contracts, that there's no way that a commercial contract regarding any use of a satellite is going to be signed off on unless there are at least declaratively cybersecurity protections and supply chain protection. So again, going back to your reference to the GDPR, so that you make sure your suppliers are compliant with the cybersecurity and that their suppliers are compliant. So that's that elegant domino effect that we have. So just 3 points on that. It is not to say that all is well in the private sector in terms of cybersecurity protections and outer space protections, but I certainly shine the light on that as something to take a look at. So thanks for that question.
Okay, thank you so much for your question. I see that EU space is another missing opportunity today. I'm sorry to not have good news for you this afternoon, but it should be fundamental to go to the adoption of the EU space as soon as we can. The problem, Mr. Breton points a lot on EU space, but the problem was the time. And the end of the government probably will be adopted by the end of this year. But what I can say for sure that this will not influence the NIS Directive 2. So member states must adopt NIS Directive 2 by October 2024, 17 October 2024, and publish the list of the entities in the April 2025. And space law will not influence in any way the adoption of the NIS Directive 2. It's a missing opportunity because for sure we need to alienate these two bodies of law, but probably should be better to start from the EU space, the needs from the space, and adapt the NIS Directive 2 probably in the, but actually I think that will be the opposite in the next future. So we are trying to understand how the NIS Directive 2 should fit into EU space law.
Perhaps, however, it could integrate a bit on the CIP part. So on the protection part, I think that there is actually an opportunity that the EU space law can still absorb. I think we can conclude. Thank you very much for really this very excellent panel. We touched upon really most of the discussion on space security and on the interaction between space security and cybersecurity law. A small caveat, I'm doctor in Italy, but academic doctor by the end of the year, so this I wanted to clarify for academic integrity. I would like just to really congratulate for these excellent ideas and thought-provoking panel. And please join me for thanking our speaker for this panel.
Thank you very much. Thank you.